If you own a business, your estate plan needs to do more than just protect your personal assets. It needs to protect your company too. What happens if you become incapacitated or your business interest isn't properly titled? Without the right planning, your company could get stuck in probate, lose value, or fall into the wrong hands. In this video, I'll walk you through the key steps every entrepreneur should take to protect their business and their legacy. So the first thing we're concerned about is making sure that your business interest doesn't get stuck in your name and be subject to a probate court administration. So if you have a corporation or a partnership interest, there's a few things you could do. You can title your interest in your revocable trust, or your attorney can prepare an assignment of interest into your trust. In that way, on your death, that interest avoids probate. So you should go ahead and review the articles of incorporation or the partnership agreement and see what you're allowed to do. You might need to speak to the HR department at your company. Also, the agreement might require that somebody else at your company signs the assignment in order for it to be valid. So you really want to check carefully on this. Now, if you're a sole proprietor, you might want to name your revocable trust as the beneficiary of an account. So how do you do this? There's accounts called payable on death or transfer on death, POD or TOD. These can be good accounts for a business interest to make sure that your assets get into your trust when you're gone, but they're initially titled in the name of the business. Now, the next thing you should do is you should always think about a succession plan. If you're a licensed professional, it's likely that only people with that license can take over your business. Make sure to line somebody up to get this started. Now, I say that so easily, but it can take like 5 to 10 years to figure out a business succession plan. So please get started now. For some licensed professionals like doctors or lawyers, you should name a practice administrator in your will. This is the person who will oversee the transfer of your practice to the next person or firm and handle the finances in the interim. Now, I have a horror story about when this wasn't set up properly. I have a client whose husband ran a successful dental practice for years. Unfortunately, the husband died, and it turns out the dental practice was just held in his name. He never transferred ownership to the trust, and he never prepared an assignment of his interest into the trust. The wife wanted to sell the dental practice, of course, but she didn't have management rights over the practice. And every day that passed, that practice was losing value as there was a risk that various patients would be leaving the practice and going somewhere else to a different dentist. We had to file for what's called an emergency probate. This took a lot of time and effort and energy and money. It was very stressful. Ultimately, the court granted our petition, and the wife was able to sell the dental practice to another dentist and get some value from it. But you definitely don't want to follow that example. If the husband had titled the dental practice in the name of their revocable trust, it could have just transferred according to the trust terms, and the wife could have had the responsibility and the management power to dispose of or sell that practice. All right, now what happens if you're a professional or you own a business or a company and you get sick and incapacitated? Well, you should make sure that someone has a durable power of attorney that allows them to run your business in the interim. You can do a specific durable power of attorney for just managing one asset, let's say your business. So maybe you name your spouse as your agent for all other matters or personal matters, but then you just have carved out this one very important role of managing your business, and you've given that to somebody else in a separate power of attorney. The other thing to think about is that there are some estate planning attorneys who specialize in doing estate planning for specific professionals. For example, I know an estate planning attorney who also has a license in psychology, and he specializes in preparing estate plans for psychiatrists and psychologists. So if you have a specialty, you can look for an estate planning attorney who really can help you with that very specialized field. So whether you run a solo practice or you're managing a growing company, estate planning is a must, not just for your family, but for your business too. If you haven't reviewed how your business fits into your overall estate plan, now is the time. And if you're in California, please reach out to our office and we can make sure that your business interest is set up properly to get passed to the right person when you're no longer able to. Thank you.
If this video is helpful for you, share it to someone else who might benefit from it.